Clause 3, recognizing the third-party House Leader.
Thank you, Madam Chair. I just make some concluding observations and maybe a final question in relation to the line of questioning. First of all, just for the record, I do want to indicate that I have two nieces who are teachers, and I am well aware of the urgency of additional classrooms and modulars and the desperate need for them across the province. So my line of questioning isn't intended to put modulars and expansion of classrooms on the Never Never plan. My line of questioning is really follows on the fact that the government has made a choice. It made this choice in Bill 7 as well, where it introduced legislation that a part of which was hardly objectionable. In this case, it's Category 1 projects, schools, hospitals, long-term care homes, cancer centers, and perhaps some ministry transportation infrastructure, whether roads, highways, bridges, and so on. I mean, who could object? And these provisions were designed, as we've seen in this clause, clause 3, to go beyond the current minister's powers in particular ways to facilitate bulk buy of modulars, or to facilitate strong project management in small school districts. Who could object? Who could object? And then we add in designated provincially significant infrastructure, Category 2 projects, and a whole range of concerns arose. And we'll shortly get to those concerns when we start to discuss Part 3. And as in the case of Bill 7, ultimately, through working in partnership with the government under our cooperation and responsible government agreement, and working with the Attorney General and responding to outcry from businesses, Part 4 was pulled. And then we worked on amendments to ensure that as the Green Caucus, we'd be able to support Bill 7. And it's, we're there, and we will support Bill 7. Here, we have a very similar situation where there are provisions and powers that one would not object to if through other parts of the bill there weren't parts that were very problematic, similar to Part 4 of Bill 7. And so this is a choice the government made. And so what we in the Green Caucus have said publicly, we don't support Bill 15. But are there parts of Bill 14 we support? Absolutely. Is the government willing to take the step that we saw with Bill 7, which is remove the most difficult and objectionable portions so that we can support the other parts? So far, the answer is no. And so far, what we've seen is the Premier pretty much doubling down on its Bill 15 with all of the areas or not. And this isn't about window dressing or minor. There's some fundamental overreach here, and First Nations and UBCM and many others have said, pull it back, pull this bill. So my line of questioning was really, if this were an exposure bill and we did the work over the summer and we brought it back in the fall, you would have what we talked about earlier this afternoon in question period, a partnership with First Nations to find the legislative approach that will have broad-based support. But I'm not getting that sense from our line of questioning and discussion that type of approach is on the table, although I will continue on behalf of the Green Caucus to make that case in committee, clause by clause, until the guillotine comes down and we're forced to pass it. But I do want to raise one option, because the minister has said, you know, yes, I won't speak for the minister, but I will take some solace in the fact that the minister indicated that, yeah, we have to do work with school districts. Yeah, we have to do market sounding. Yeah, we have to consult and engage with First Nations. And, oh, by the way, we can't assume what First Nations will come up with, because in the very interim approach to implementing Section 3 of the Declaration of the Rights of Indigenous People, October 2022, Article 19 of the UN Declaration, which we are following, is states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior and informed consent before adopting and implementing legislative or administrative measures that may affect them. So it's not just that the legislation theoretically wouldn't pass in the fall if we wait and do an exposure bill and do the work. It may be that the consultation process with First Nations does not secure their free, prior, and informed consent to this legislative framework. But making the effort to see if we can get First Nations and government together, working as partners, is far preferable to the 100% guarantee of litigation and First Nations opposition if the bill is passed in its current form. So what I want to conclude by saying, through the chair, and a question for the minister, if the minister was able to be assured that passage of the portions of this bill that relate to schools, hospitals, long-term care homes, and cancer centers, that subject to First Nations being comfortable, that you would have the support of the Green Caucus to pass those portions in October, would you be prepared then, because you would have the assurance that you're not working with a legislative framework that won't get passed by the legislature, would you then be prepared to take more time and spend time with First Nations to discuss this bill in a lot more detail? So just to be really clear, through the chair to the minister, for the Category 1 projects and the provisions that relate to those projects, if you were provided assurances, they'd have to be negotiated and mutually agreed, that in October, subject to fall session, subject to First Nations being comfortable, would you be prepared to proceed with this as an exposure bill so that you can do the necessary engagement with First Nations?
Recognizing the Minister of Infrastructure.
Thank you, Chair. I'm going to be candid. I'm not comfortable answering this particular question because it is rooted in a lot of presumptions, respecting, of course, that the member has every right to promise his own vote on a future hypothetical version of legislation. It is the privilege of the entire House to vote on legislation. The member seems to be implying that he is also able to promise the securing and a positive vote on behalf of other members. It doesn't seem like an appropriate hypothetical situation for me to engage in. Thank you.